Your Lordship.
It's not in my assignment. Even if I've disposed of it earlier,
Yes, Your Lordship.
it will not come to me. Go to the assignments. Make a mention before the DR. Yes.
I mean, item 74, I may be permitted to draw.
74.
My lord, all the items, in the 74, 3 items are there, all the items.
All the items. Sorry.
My Lord, yes, DRPCI.
Yes.
Supplementary list item number 1.
And in this case, senior Mallet had already placed the dead set and the case Mallet in detail.
Your Lordship specifically directed, order may kindly be seen.
On the, because I had not filed a counter Mallet on the last occasion.
There's a last order is that comprehensive affidavit shall be filed in the meantime after serving copy on the other side positive.
Yes, sir.
5/3/2024.
So,
Yes.
Mallet,
No, 3/4/2024.
yes, ma'am.
That is the last order.
That is the last.
Last order is the 5th of March.
No, no,
No,
no.
no.
There's a 3rd of April.
Third of April.
Oh, 3rd of April, time
Yeah.
Comprehensive chronological.
Mate diya hitla another
Acha, acha,
opportunity. Mallet, I'm filing it.
You're filing it today.
I'm serving a copy of this. My lordship.
Calculation of appropriate scale of pay in different grades to be reckoned from 1/6/1986 as claimed by you, said that being the date on which this service is approved. The court would like to know the response of the state specifically on the contentions raised by the petitioner.
Yes,
So you were directed to file a comprehensive affidavit.
that I have already filed Mallet in this case.
After hearing
And
the
not like-
comprehensive reply was to be filed.
Mallet, we have
That is why,
it.
that is why
It's of submission.
5/3/24 order টাকু. He was categorically say
This is to be treated as a comprehensive affidavit.
The
As the-
comprehensive affidavit answering all the points,
All right.
whatever it has been asked, including the decisions which they are relying.
All right.
comprehensive affidavit দেবে মুতাবিক দরকার পড়ে রিপ্লাই দেবেন
They are saying that this is the comprehensive.
that should be record of.
Yes, yes. Sri S.N. Patnaik learned AGA files counter affidavit on behalf of opposite party number 1 and 2 and submits that this affidavit is to be treated as the comprehensive affidavit as directed by this court, as it covers all the points raised by learned counsel for the petitioner on the last occasion. That's all. So you want
At least I'm to go through that.
a copy of the affidavit has been served upon the counsel for the petitioner in court who wants to respond to the same. List this matter on, when do you want, sir?
I may have it sometime in 22nd
Or 29th April.
or 15th,
29th April.
29th.
Yes. All right, list this matter on 29th April. Parties are requested to come ready for final disposal for hearing. Yes. The 2004 matter we finished off.
More to survey thili. Upon because they had not given any reply to the point raised when it was discussed. That was the direction that you give you have not given reply, give a comprehensive reply.
So right now that the reply has come.
It has now. I will not take any time, sir.
Yes.
Item number 2.
Item number 2. Television athre ki thre, ek is-
Nah, because nobody appeared on the last occasion, today it was.
Kyo book thila? Dekho previous order ta?
It was previously on my lord.
No, no, appears for the petitioner. 3 tarikh.
This is a matter relating to engagement of the Sikhyasak on the basis of a certificate.
We'll dispose
Which
it
we
all.
have, yes, which we have stated that my lord, it is not equivalent.
None appears for the petitioner on repeated calls. On the previous occasion also, there was no appearance. This being a case of the year 2009, I'm not inclined to grant any further indulgence to the petitioner. It is presumed that the petitioner is no longer interested to pursue this writ application, which is therefore dismissed for non-prosecution. Yes.
Item number 3.
Item number 3, though they had filed the rejoinder since 11, I need to have some instructions because the impugned annexer said that it was illegal appointment.
Last occasion.
Now they have come up with
I'm sorry.
the plea that this was irregular appointment. So that instruction I need to have, and they have impeded the finance department after amendment.
Finance department as well as the chancellor.
Chancellor.
Yes.
Who's appearing for the chancellor?
Sir, Lordship, we contacted the council appearing for the chancellor earlier. He
Mr.
said,
Udgata.
Lordship,
Yes.
He said that notice may be issued.
Notice has to be issued, already there will issue notice. It appears that that notice has not been issued to the newly added opposite party number 5, Secretary Chancellor from Utkal University of Culture, Odisha. Let notice be issued to opposite party number 5. The newly added opposite party number 5 by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Place this matter on
9th May.
9th May. In the meantime, London State Council shall obtain necessary instructions with regard to the grounds taken in with regard to the amendments made in the rejoinder.
Yes.
Yes.
Lordship, so
If
far
it
as
is
the finance-
irregular, they have a better case,
so far
as
as
your lordship knows.
so far as the finance department is concerned, Lordship may be permitted to file extra copy.
Extra copy is necessary.
সেটা কোনো-
अनुग्रह दरकार
Lordship, interim order to continue.
Interim order to continue.
Oh, bless you, Lordship.
Item number 4.
Item number 4, my lord was kind enough to, my lord, is a case where the son of the petitioner is critically to be treated at outside country, and my lord was directed to file a comprehensive affidavit and order dated 11/3/2024. So my lord was pleased to observe about the affidavit and directed that I may permit to place para 3. Let instruction be obtained as regards to genuineness of the claim of the petitioner's son is suffering from eye ailment as mentioned and requires treatment at Singapore. Secondly, this court would like to know the response from CBI as regards to amendments made in paragraph 8 of the affidavit, where 8 of the affidavit fleet chance. Is this matter on 4th?
Yes. What is your instruction, Mr. Naik?
On instructions, I would like to submit your lordships that he's actually having eye ailment, the boy. And that 5 crore rupees which he has deposited, that is reflected in the bail order. But just because he has deposited 5 crore rupees, he is not going to abscond or flee, is not my submission, your lordships. He has deposited it, it's a part of record. As the investigation is still pending, your lordship may record my objections and pass necessary.
Got it. No, but I'll have to say that you have no objections to his government that he has an eye ailment. That is what the instructions you have obtained as directed by the court. So that has to be.
Yes, that your lordship, on instructions from the IO.
Yes, yes.
Yes, that he's having problem.
Sri Sarthak Naik, Learned Counsel for the CBI, submits on instructions from the IO that the son of the petitioner is in fact suffering from eye ailment and requires further treatment. He further submits that
Requires further treatment or not, I don't know, your lordships, but he's suffering from ailment, that instructions I've got. Wow. Because your lordship,
you challenge it. I
kind of
mentioned it, you challenge it in the Supreme Court.
no, your lordship, kind of
My lord,
because
I made Supreme
your
Court.
lordship, there is a reason behind it. Because your lordship, he's like.
He doesn't require further treatment, even though he has a eye treatment.
No, you're listening, why
I
I'm
have not said at
telling-
Singapore. I have not said at Singapore. I have said simply further treatment.
Yes, your lordship.
Required.
Because
Yes.
yes.
Then what about that something you were submitting about that 5 crore deposit?
Yes, that is there, deposited.
That
as
is
per
that is on record, your lordships.
cash security, 5 crore deposited. That is his admits.
Thanks, he could it.
The same bail order is.
Para 8 of the affidavit.
Affidavit filed by the last affidavit.
Again.
Bora affidavit.
My lord directed
What is the IA number? The khali affidavit is the
affidavit
filed by the petitioner accused Vinit Lalani. Say it.
pursuant to the order dated 20th February 2020.
Okay, it is submitted after filing the application for modification. The petitioner deposited rupees and deposit an amount of rupees 50 lakhs, not 5 crores, and placed to the 50 lakhs. 5 crores किमती हो?
5 crores. Para 8. 8 है क्या? ये जो affidavit टा देते लिखते
जो मैं आउटर को
हैं affidavit टा जोटा कि Hon'Ble को direct करते वो फाइल करते ता fleet charge टंका deposit एवं से फेरिबो ये part ऊपर वो देते
this affidavit
that is on record.
pursuant to order.
That's a bail order dated 7/68 of 2015. Order dated 11/11/2016.
Just let me see. rupees 5 crores, yes, in the shape of fixed deposit, fixed deposit STDRs obtained from any nationalized bank. So he was granted bail.
Yes.
Then what happened?
When I was cooperating everything, now my son came with accident of the fire accident. So that is why I filed IA.
You were granted bail. How? Why is this?
The charge sheet is filed. Everything is
This is a modification.
Modification.
Okay, okay.
Ground number 4 and 5.
All right.
Condition number 4 and 5 to be.
So, but that paragraph 5 जो कोहा है ना, see paragraph 5 time as regards the amendments made under paragraph 5 of the affidavit. So paragraph 5 of the affidavit. When did you find that this is the affidavit? Isn't it?
Yes, madam.
That I have pledged cash securities to the tune of rupees 5 crores and I have no intention of about this indefinitely 10 days. Bola. But where is that? No, this is another affidavit. This affidavit is, I am unable to find it. Who is it?
A affidavit.
Acha. It's at the last.
Last.
As regards the amendments made in paragraph 8, Sri Naik again submits on instructions that the petitioner has furnished cash security of rupees 5 crores as directed by this court in order dated 11/11/2016. Stop. So what is your objection again?
Your Lordship, may kindly read the prayer.
Prayer of the modification.
Yes, Your Lordship.
Application,
The
yes.
prayer is to modify condition number 4 and 5.
Yes,
Lordship, condition number 5 is completely different. The
Four,
condition number
4 and 5 below reflected page 3 of my IA.
No, he is the place by modifying previous order dated, miscase number so either by allowing or permitting petitioner to deposit within 3 months. No, that is not there. I would modification. It's IA number
IA number मिलट 1478.
Okay.
सेथरे page number 4 रे clearly मिलट सी condition number 4 and 5. जोटा कि
we have relaxed the condition of 4 and 5.
मतलब मोती मंडरे जाई करी मासर प्रति मंडरे पहुंचीबो एवं जेतु मोर सबमिशन चार्ज शीट इज ऑलरेडी फाइल्ड 3 times
charge sheet is not submitted, Your Lordship.
but if my friend is saying his
Your Lordship,
doesn't require he will appear.
Your Lordship, that's a wrong submission.
In another accused, my lord was the honorable court have relaxed that condition. Yes, तमे जाओ जेतरो दरकार हबडा क्योंकि प्रति मंडरे सेटा
Your Lordship, further investigation is pending in the case.
yes, I don't mind. That is, I will appear as and when required. But Monday part, whoever be already court condition, that copy I may also bring in.
Yes, yes.
Your Lordship, may kindly read condition 4 and 5. Condition 5 is that the petitioner shall appear before the lower court on each date of the posting of the case and shall also appear before the IO on the first Monday of every month until the investigation of the case is finally completed.
This is condition 5, not 4.
Yes.
5.
Yes.
My respectful submission for that part, Your Lordship, is that investigation in this case is further continuing. Final charge sheet has not been filed. Therefore, this condition should not be waived, Your Lordships. Number 2, the petitioner shall surrender his passport before this, and if he has no passport, has already surrendered, he shall swear an affidavit to that effect to the satisfaction of this court. This condition he wants to waive. But this, if Your Lordships is going to allow this is for a limited period of time. Therefore, it should not be fully conditional, Your Lordships. This period should not be fully allowed. Yes.
All right, fair enough. But his appearance before the court on each date of the posting of the case when he is in Singapore attending to his son.
Only on that date will not be. Yes.
Yes. Only as long as you are in Singapore, only that to that extent only. Yes, correct. In this petition for modification, it IA order 1478 of 2022. In this petition, the petitioner has prayed for modification of order dated 11/11/2016.
Bro, that is
18/10/2016. 18/10/2016. To the extent of waiving / relaxing the condition number IV and V imposed therein. This court, by order dated, is it 18/10? That order is 18/10.
Again, 1810 order to pass it.
No. You have hearing 18/10. Judgment is 11/11/2016. You
Your Lordship,
corrected the court.
Your Lordship,
Sorry.
Your Lordship just got a message.
11. Yes, sorry. I'm very sorry. Yes.
Lordship, I just got a message from IO. I'm not sure, Your Lordship. It says that the order was modified on 11/11/2016.
Yes.
No, that's the, I have the judgment before me.
And
The date of hearing, it is written 18/10/2016. Date of judgment is 11/11/2016.
I'm very.
No, Your Lordship, that
Sorry.
5 crores he's saying that it is 2 crores. The learned counsel for the petition can clarify.
No, I think I've read it, it is 5
Yes,
crores.
that is 11. That
It is
is
5 crores.
It was modified on 11/11/2016. I may be wrong.
No,
Your
no,
Lordship.
no, I think he's wrong. 11/11/2016 order টা প্রমো সামনে খোলা আছে, and there's the judgment by Justice B.K. Naik.
11/11/2016, Your Lordships.
Yes,
Yes.
11/11/2016. সেটার date of hearing টা দেখাইছে 18/10/2016.
Yes, that is.
I don't think it has been modified at all.
Modified and it became 2 crores, Your Lordships. You
No.
can see it.
No, it has not been modified. He may be confusing it with some other case, but here it has not been modified. That was order number, I tell you, it order number कितना होगा? Order number 24.
Order number will add.
Order number টা সেটা লেখা
Order
है? Order number 24 না कितने সেটা?
But I have the file
Sorry, order number 30, 34, 35, 36. 36 is my order.
Yes.
Where the last order.
Yes, correct.
Anyway, why?
I have held the affidavit. 5 crore I have deposited. Move forward.
No, you change, correct that.
That is 2 crores, Your Lordship. The IO is saying that 2 crores. It may
No,
be very
no judgment ଅଛି ମୋ ସାମ୍ନାରେ, modification ତ ନାହିଁ.
No, Your Lordship. He's saying that comply the condition of the bail. Honorable High Court on 16/12/2016. Honorable High Court modified its own order dated 11/11/2016 and modified condition number 2.
16/12/2016. Let me see. All right, let us see.
Dekhe
It could be, देखिए.
I may be wrong, Your Lordships, but
No, देखिए. It could have been, may have been modified also. If the IO is saying he may be having information, how do you know that? 11/11/2016 is the order where 5 crores was one of the conditions. Then the next date was 9/12/2016. 6/12/2016. Then 9/12/2016. Then 16/12. Yes, there is a modification. No, it has been modified to 2 crores.
because I called the IO at 6 in the morning, Your Lordships. I
That
told him
is-
to check everything. So he should have.
Could you know order can be passed? It has been modified. Your affidavit is wrong.
I'm sorry. I'm very sorry.
Oh,
That
Your
is-
Lordship, he knows it.
I'm very sorry. That
Because,
is
because Your Lordships,
It is my, maybe not that is.
why he knows it, Your Lordship? Because the accused himself must be knowing about the modification of.
No, that may be, but I may be sorry. I'm still sorry, my lord. That is.
And Your Lordship, there is a judgment if somebody courts to come with.
Yes, that is the- once the record
contemptuous in
says-
nature also.
Because I was not the counsel at that time, my lord, recently. That is, I'm very sorry for my.
No, your client is not instructing you properly.
Yes. I'm very sorry, my lord. Mr. Naik is
All right.
not correct.
All right, ସେତିକି ଲେଖିଥାନ୍ତୁ ତାପରେ ଲେଖନ୍ତୁ prayer କାଟି ଦିଅନ୍ତୁ, କାଲି ଲେଖନ୍ତୁ ଶ୍ରୀ Sashikanta Mishra, learned counsel for the petitioner. Some in course of hearing, it is brought to the notice of this court that the condition number IV of order dated 11/11/2016 was subsequently modified in directing the petitioner to furnish cash security of rupees 5 crores was subsequently modified by order dated 16/12/2016, passed in miss case number 1053 of 2016, in reducing the amount of cash security to rupees 2 crores. Sri Sashikanta Mishra, learned counsel for the petitioner, submits that he has no instructions in this regard, and therefore he requests for some time to obtain appropriate instructions from his client. Stop. List this matter. I am just giving you 10 days time.
But I'm very sorry. Yes.
It's already, you can not press.
I
this
will not
button.
be loyal. That 5 crore part because.
I also place
like I say,
Your Lordship, I also want to place a judgment, a recent judgment of the Honorable Supreme Court by Honorable Justice Mr. U. Lalit. While bail order, if somebody is trying to come to court with unclean hands, that is contemptuous in nature also.
No, that.
One
That
petition.
is not saying.
Thank you. With this matter, okay, आज कितना तारीख है? 6 तारीख. 18th.
Your lordship.
Is this matter on 18th?
Right.
Yes.
Item number 5.
But I'm sorry, my lord, that instruction because I was not the lawyer.
You are take your client to task
Yes,
and tell him
I'll definitely.
that I am going to reject it only on the ground.
Well,
What Mr. Naik said,
well,
I may not have passed any order, I did not take
I'm
over.
very
Don't
sorry.
think that whatever he has said is absolutely correct. This is contemptuous.
If you not say 5 crore and 2 crore, that is not very.
তাহলে court বিষয়ে কোন দিন আগে আমি 5 কোটি দিয়েছি?
Yes, yes, that is. You say that affidavit say
No, I'm not blaming you, Mr. Mishra. Obviously, you would have been instructed otherwise. I would have, it was very good. Now, the High Court would have passed an order that he has deposited rupees 5 crore.
बुएटा आज्ञा से तक मते पठेला इंस्ट्रक्शन ड्राफ्ट हैला वेरीफाई हैला
You take him to task.
Yes, sir.
Otherwise, I will do, I will pass, I will cancel the bail.
appear and he will not do that.
I will cancel the bail. I tell you, it will not take me much time to cancel the bail.
Very sorry, my lord. I am very sorry.
Yes. Item 5. Is this?
Some 5, my lord. He was released on bail on 27/9/2022.
Submit that in bail corresponding to match the court was used to release the accused on Sarman bail. You can say he shall appear with his each date of posting, but the said accused did not appear in the under the Orissa NBW has been issued against the said accused. Yes.
To the morning, I took instruction that since September 22, my lord, he was regularly appearing before the learned trial court. On the last occasion, there was he instructed his counsel who is appearing before the learned trial court to file an application. Thereafter, I don't know.
He could have obtained the modification of the condition from imposed by this court instead of. How can he overreach the order of this court?
No, that I don't know what
No, nothing. NBW has been issued. Let him be taken to custody. That's all. Simple.
NBW has been issued.
Yes.
In fact, I have no.
No. I will keep it pending for only one week time. I'll grant 1 week or 10 days time for execution of the NBW. If it is not, if the NBW is not executed, I'll cancel the bail. As simple as that. It has violated the condition of the order. It's a very good ground for cancellation.
Yeah, that I. Like,
So, like, I'm very well, you know.
No,
Very well. Granting bail and cancelling.
report I have no knowledge of. Yes, that is the. Yes.
With reference to the subject indicator, this is being written by the additional district and session judge.
This is one that alone trial.
As it was also, the Honorable Court was pleased to release the accused, namely Om Sharma, on bail with a condition that he shall appear before this court on each date of posting. But the said accused did not appear on the date of posting of the case, that is on 14/3/2024, and violated the condition of his bail. Under the above circumstances, NBW has been issued against the said accused for his apprehension and production.
On 14/3, man.
Yes,
Yes,
he doesn't have. All right. The code letter has been
To
received.
keep it 2 weeks after, so that in the meantime he can.
Letter has been received from the court below stating that the accused petitioner did not appear on 14/3/2024, the date of posting of the case, and thereby violated the condition of his bail. So, as such, NBW has been issued against him for his apprehension. Stop. Sri Niranjan Lekal and counsel for the petitioner submits that he has no instructions in the matter and requests for some time. List this matter on 10 days time. On 16th April. Yes.
22nd at least.
No.
Is an outsider, I have to tell.
No, sir. 16th April, the court below is directed to ensure early execution of the NBW. Yes.
Item number 6.
Item number 6, I may be permitted through BC, my lords. By the order dated 27/3/2024, my lord, lordship was pleased to grant bail. Now the registry has sought for correction of the same order because the year of the case has been wrongly typed as.
All right. Corrections be made accordingly. Corrections be made appropriately.
Your lordship.
Item 7.
My lord, difficulty is that the same has been uploaded in the website and the certified copy has also been sent
So
to
you
the.
will have to submit the certified copy for correction. The certified copy which you have taken, I'll pass that order, you will submit it for correction.
Your lordship authorize any officer to make the correction so that I can do it.
No, we will, you see, the order has to be corrected. And if the certified copy of the previous order has been taken, then it has to be also corrected. So you have to submit, you have to file the certified copy before this court. The certified copy granted to the petitioner be submitted for necessary correction. Yes.
Item number 7.
7 upon letter SC.
7 my lord, letter from the
Yes.
concerned lower court below.
About 6 months time for further disposal.
Eight people come up.
4 months time is allowed to the court below for disposal of the case. Yes.
Item number 8. Item 8 may please. The extension time to surrender my lord. My order is 6/11/2023 my lord.
First time it has come.
No my lord, this is third time my lord.
Third time.
Third
One.
time.
Our one.
My lord, the problem is that my lord, they both are ladies my lord. They are ladies, they are doing job in Hyderabad my lord. The learned trial court advocate, they are communicate the order my lord. That is the problem. That is why as a last time, my 1 week time I given.
As a last chance, 1 week time is allowed to the petitioners to surrender. It is made clear that no further time shall be granted.
Not so like. Item number 9. 9 also same my lord. That is the extension time. Item number 10. Not so.
Item 10, extension of time, my lord. 3 SC.
It has come for the first time.
First time, my lord. No, 3 weeks.
2 weeks time. Yes.
Item number 11.
Yeah, please. Last occasion, your lordship had granted 1 month interim bail period.
Yes.
And his voluntary surrender before the sub learned session judge court on 22/1/2024.
No, this is a fresh matter.
No, IA filed, my lord.
No, what order was passed in the main bail application? Where is the order sheet? A fresh matter, okay?
Fresh matter.
This is a fresh matter.
Again, he has filed the IA on the account of his mother.
This is a fresh matter.
Yes.
This main bail application has not been heard.
No, my lord.
Now he has filed. He's filed an application for interim bail.
Yes. On accounts of her mother's
On account of
Wife,
wife, the mother.
wife.
wife. Time of admission on 28/3/2024. For date of discharge is also 28.
Wife of the petitioner.
So, what is the ailment? Nothing has been mentioned.
Cardiac arrest.
Cardiac arrest. Arrest so is she alive?
No.
Oh.
Cardiac due to cardiac ailment. Say it mortis.
Oh, so Modi is in. So, but you have given a discharge certificate. This does not say.
Ambulance service jo for death and referral patient, my lord.
Okay.
Lekha hai ji.
Okay. So his wife has passed away. When was it? 28. Sorry.
Today is the 10th day.
10th day. Okay. Therefore, interim bail has been made on the ground of death of the petitioner's wife. It is submitted that the petitioner's wife died. She died on 28/3/2024. A copy of the slip issued by MKCG Medical College Hospital for ambulance service has been enclosed to the IA. It is submitted that the 10th day ritual, that the rituals connected with such death are being performed. Learned State Council fairly submits that, considering the ground on which the prayer for interim bail has been made, the court may pass appropriate order. What is the offense?
302.
Yes.
302.
So we'll keep it pending and we'll grant him interim bail?
Yes, ma'am.
Yes. Having regard to the submissions as above and the ground on which the petitioner seeks interim bail, I am inclined to take a lenient view. Stop. Let the petitioner be released on interim bail for a period of 2 weeks. Yes.
My lord, 1 month.
2 weeks. 3 weeks. All right. 3 weeks.
In course of the day, certificate copy release.
Yes. Bail application release this matter 3 week that would be fixed. Yes.
Yes, ma'am.
I think that matter was already disposed of. Why it comes again?
Yeah.
2 weeks extension also granted, disposal. 14/3/2024 dispose of it.
14/3/2024.
2024, this year. 14/3/2024.
I think it is 2/2/2024.
সেটা তো মেন বেলটা দিয়েছিল এক্সটেনশন
Extension order টা দেখলে বার করো। इधर नहीं ये ऑर्डर शीट नहीं नहीं से जो मार्च मासेर ऑर्डरটা তো নাই তাদের ये फिजिकल कॉपीটা আসবে তাহলে 24 মাসের পার্সন অর্ডার সে ফিজিক্যাল কপি আসবে আসবে না করি বার করে দিবে ওকম বার করে দিবে ওকম সে অর্ডারটা কোড হলো where are you saying that the order was modified
14/3/2024.
14/3/2024 you have a copy of that order
I had already sent, but the copy wasn't moved. So the copy is with me.
কোন আছে নাই इधर নাই अपलोड is कल अपलोड is टू वीक्स ही कौन है ये इधर स्कैन किया ही नहीं
14 मार्च रहेगा
That I was also disposed of.
It has been disposed of. There was no direction to list it. This has been wrongly listed. It appears that the matter has been listed wrongly. Matter be delisted. Okay. Yes.
item 13
Big apology, one. That I have 5.5 कोटी 3.5 कोटी से FDR देची और 1.5 कोटी कोलेट. That is one mistake here. The 5 crore is 5 crore. That was only reduced. I have scolded him, and he is coming with a total way. I will file affidavit. I may not have misunderstood. I am wrong, but 3.5 कोटी देची.
Don't side with such clients, Mr. Mishra. You have a long career.
Yes.
You have a long career. You are a good counsel. Don't side with such unclean clients. I am going to cancel the bill. I will cancel the bill. You know me. You know the scope.
That is only because we are.
No. Don't identify yourself with those clients.
No.
I will take him to task. Why did he mislead? Why he wanted to mislead the scope?
5 crore cash. He quitting.
So naturally, I thought that 5 crore somebody has that weight upon my mind. I tell you, yes, I openly say if somebody has come forward to deposit 5 crores, it shows the bona fides.
But he has done it that way by reducing reduction. I was not the counsel, earlier counsel there. Reduced 3.5 crore he deposited the cash security in lieu of fixed deposit and 1.5 crore. 5 crore his ballot is saying it's okay, but he has misled and not come out clean that this is the split of.
How can he deposit 1.5 crores when the direction is to deposit 2 crores?
No,
after modification.
3.5 lakhs, 5 crore is there. But I have brought I've asked all the documents and file and personal.
You examine it and then
3.5 crore cash in lieu of FDR, fixed deposit FDs. And 1.5 was collateral security of flat.
Let us see. Let us
all together.
Let us see. Let him produce the documents.
Let him produce the documents. But I may be excused for my.
No, it's all right. All right. Yes. Item 13.
item 13
For permitted to withdraw.
item 14
May I please, your lordship? My lord, item 14, modification for change of court, my lord. In the cost title and in the para 3 in the order.
The mistake by the court.
No, my lord, our mistake.
Learned counsel with the petitioner is permitted to correct the name of the court appearing in order dated 22/3/2024 in court. Huh? Oh, 2024. You will be permitted to correct. You will correct it in the office.
My lord, and extension of time.
2 weeks for the time. Yes.
Okay.
Sorry, very good. Weekly.
quickly list item number 96
pass over item 93.
Password सब साला पर password. Let us run through the entire list, then we'll come back.
Yes, yes.
93.
item 96
96. Yes. Now, chalo.
item 97
Chalo.
item number 98
97. 97, yes, pass over, yes. 98,
98.
yeah, 99,
वो तो जानना है।
yes, pass over,
Item 99.
Lord, I will plead your access.
yes.
Lord, petitioner is in custody.
Your matter, Mrs. White? Yes.
Last occasion, we received information that this was transported to CIDCB.
Yeah.
So CD was called for. Let it be some time.
My lord, CBI filed a charge sheet, my lord. So far, my instruction concerned.
CBI? What CBI?
Sorry,
Crime branch?
crime branch has filed a charge sheet, my lord.
Is a case of murder? Or what?
Lord, no, Lord.
19 and
We are uploading a photograph now.
19, 420.
294 actually.
Fake app and cheated, I think. Acha, how? Leonard State Council requests for some time to obtain the case diary.
And Lord, in the meantime, charge sheet has been filed.
So everything.
Leonard Counsel for the petitioner submits that in the meantime, charge sheet has been filed. Be that as it may, let the case diary be produced. Let this matter on in the week commencing 22nd April. Yes,
Fine.
22nd April, week commencing.
I don't know.
Second item is mine, my lord.
Second is this is 98.
99.
99.
Oh,
Same order. Aye, yes.
I do. 100.
The applications are there. I am appealing for one of the accused, Lakshman Madi.
Wait. When you were moving the person for collection of evidence. He has not committed any crime. He was just moving around with an ID card.
He is the mastermind. ID card is against the Kishore Mishra.
Yes.
He was identified as Assistant Commissioner at Then my lord, he told that the present petitioner along with others, Kanu Chandra Pradhan, they have cheated more than 40 crores to the people.
50 crores.
My lord, 40 crores rupees. And there is some transaction is made between three accused persons.
This Lakshman Madi. Lakshman Madi is the
Lakshman Madi is a boy
petitioner.
about 19 years. His account only used for
what is the
Financial total transaction was 1.2 crore, which is under verification. But Kanu Pradhan, he has transferred 61,99,499 to the petitioner's account.
and that account has been seized, my lord. And the person Borun Mishra, he has been granted anticipatory bail, and the person Kanu Pradhan, his bail application is there. I also filed an affidavit. He has been granted bail by the Honorable Appellate Court.
This is the my instruction last page, my lord.
Charge sheet submitted. Always in the statements till that they have collected. No one has made any.
Kishore Kumar Mishra, 41A complied.
That I am submitting.
Kishore Mishra,
Initially, they may not.
How many accused persons first tell me?
3 persons.
4 persons.
Okay.
One is Kishore Mishra, who is inside custody. Bail application is pending along with this item. One is Lakshman Madi, that is present application.
You are Lakshman Madi.
Yes, my lord. And one Kanu Pradhan, whose bail application is there. He has in the meantime he has been granted bail by Honorable Appellate Court. And another is Borun Mishra, in which
He has been granted bail.
granted anticipatory bail. So, where the Kishore Mishra is concerned, initially 41A was complied, and subsequently he was arrested and taken into custody. So, the Lakshman Madi is concerned, the entire 161 statements are collected from different persons. They have stated that Kishore Mishra impersonated himself as the RTI activist, and he stated that I have contact with Kanu Pradhan and Borun Mishra. They will facilitate to obtain the license like liquor license or bar license, etc. And by this process, they have collected money.
So where the present petitioner implication is concerned, he is only 19 years boy, having no criminal antecedent. His account number has been used by the Kanu Pradhan, and to this the account number of the petitioner, that is Yes Bank, that is in the meantime has been seized. Amount of rupees 60 lakhs has been transferred by the Kanu Pradhan. And he, in the meantime, charge sheet has been submitted, and he is in custody since my lord 10/10/2023.
Accused petitioner Lakshman Madi is a close associate of mastermind of instant case.
Well, admittedly, there were 61 lakhs was transferred.
One statement I am reading.
Through. Sir, Kishore Mishra has collected money.
Yes, ma'am.
Transferred more than rupees 60 lakhs to US Bank account number of petitioner Lakshman Madi. So 60 lakhs has been transferred to your name.
That account has been seized, and
the amount has been frozen.
That is not with me. Whether
the account is seized, but in the meantime, that Kanu Pradhan was using that account. He has withdrawn the amount.
That belongs to
has been granted.
No, but as it appears, in your bank account, transaction of more than rupees 1.2 crores was made. No.
Charge sheet is only 60 lakhs.
No, charge sheet may be 60 lakhs, but that is still under verification.
under verification.
So you obtain specific instruction as to the role of the petitioner. Because this, except for saying that there are two things. First is, he is a close associate of that main person, Kishore Mishra.
Right.
And secondly, he, to his account, 1.24, actually 60 lakhs, initially
61 lakhs. 61 lakhs, 99,490.
that amount was transferred, but the total transaction comes to 1.2 crores. What happened to that amount? What happened to that?
I will take whether the 61 lakhs was secure.
Well, its State Council has obtained written instructions from the IO, wherein it is stated that the petitioner is a close associate of the mastermind, Kanu Charan Pradhan. So, it is further informed that it is further stated that more than 60 lakhs was transferred by said Kanu Pradhan to the bank account of the petitioner. It is submitted by learned counsel for the petitioner that the bank account has been frozen, though the money deposited therein had already been withdrawn by co-accused Kanu Charan Pradhan. So, learned State Council shall obtain specific instructions in this regard. List this matter on in the week commencing 22nd April.
The 11943 may be not pressed because he has been granted bail by the
11943 not pressed. 1247744.
other council. And
Seedra Ashu Kathe. Yes.
not pressed.
Mojita not pressed. Arata. Yes.
101.
My lord, the petition is in custody since 20/10/2023 under section 21B/29 of brown sugar. My lord, nothing has been more to khali pudiya kagaj pudiya seiji. I will 19 gram 90 total 2 জন involved ଅଛନ୍ତି 19
ଚାଷୀ ହେଇଗଲାଣି
Charge sheet submitted.
ଚାଷୀ submit roll. The petitioner is in custody since
2010-23.
2010-2023 in connection with such and such case. It is alleged that the petitioner and another person were moving in a motorcycle carrying contraband in a suspicious manner when they were stopped by police. Stop on search. Brown sugar weighing kete gram?
19 gram, 90 milligram.
19.90 grams was recovered from their possession. Stop. It is submitted that no contraband was seized from the possession of the petitioner except for except for an empty packet. In any case, charge sheet has been submitted and the seized contraband is less than commercial quantity. Correct. Taking note of the submissions I have allowed, the bail application is allowed. Let the petitioner be released each day appearance.
Item 102.
Wait, please, Your Lordship. My lord, subsequently, the police investigate into the matter and arrested the present petitioner and forwarded the petitioner under section 363, 366, 376 2N, 376 A.
Not received prisoner's petition?
Already from second.
No, there is no prisoner's petition.
107.
Yes.
107, I am approving.
So, taking it from jail.
Where is the prisoner's petition? It is not there on record.
28th March, already come to jail, but not attached the file. Can urgent to next week, any day.
On what basis should I adjourn when the counsel is present? The counsel on record is present. You say that you have been instructed by the petitioner to appear through a prisoner's petition. That prisoner's petition is not there. So what can be done? How can I ignore learned counsel who is standing here, who has the power? You may have Vakalatama, I am not saying, I am not. But Vakalatama without his consent will not be accepted first. Prisoner's petition allow prisoner's petition nahi kaun kare? Yes, Mr. Kuntia, what do you say? If the petitioner actually wants to change his
instruction. I don't have instruction.
Your good name, sir?
Mangu Nandi.
Yeah?
Mangu Nandi.
Mangu Nandi. Sri Mangu Nandi, learned counsel, appears and submits, comma, he has been instructed to appear on behalf of the petitioner. And according to him, a prisoner's petition has been sent to this court. No such petition is available in the case record. Sri J.K. Khuntia learned counsel, the earlier counsel is also present and submits, he has no instructions in this regard. List this matter in the week commencing 8th April. Office to verify, stop. Office to verify if any prisoner's petition has been received. Stop if so, same be tagged to the case record. Yes.
Item 108,
That's what.
item 109. Short the copies, extra copies, last copy.
Extra copies?
The issuance of notice to the.
Yes, notice.
Yes, my lord. Notice has been served on 21/3/24.
All right, London State Council submits that notice has been served on the informant slash victim on
21/3/24.
There is how no appearance for which the bail application is taken up for hearing. Bond करते हैं छुआ मैंने.
My lord,
Yes.
yes, the accused is in jail custody
The
since
cold matter.
X of 5 weekly.
Hey, wait karo. Hare se pass out to abo to kabo. Wait karo.
May I please, Lordship, 111.
111.
The petitioner is in custody since 26/11/2023, my lord. In the meantime, charge sheet has already been submitted.
Gone karo. Used
Yes, I am in custody. Section 25 NDPS Act says that if on the knowledge of that owner Miller, so there is no allegation that with my knowledge the vehicle was used, Miller. There is no such allegation.
Well, the fact itself proves.
I am only.
You don't say that your vehicle was ever stolen. You don't say that you have not lodged any FIR against the driver saying that you have taken away my vehicle without my knowledge or loaded something without my knowledge.
This is a Miller. The vehicle is that is Bolero pickup van Miller. That is a Miller usually used Miller as a Miller rent purpose Miller. And here what happened? The driver Miller fled away, and these two persons were Miller arrested. Satyam Lodhi and that, and this is not a private vehicle Miller. So Lordship may kindly consider I am Miller. I am in custody since 21/11/2023 Miller.
Direct involvement is you. You are the registered owner, or you don't say
Registered
that.
owner, but there is no such allegation that I am with my knowledge that.
Need not. There will be a presumption. You have to rebut that presumption. In 63 proceeding, when a 63 was there, confiscation like it. Oh, no problem. Confiscation.
This vehicle Miller used in a higher purpose Miller because it is a pickup van Miller. Usually these with Miller used as higher. And here Miller, the Lordship may kindly keep it to some another date. I will Miller have.
Examine section 60 and 63. As requested by
his own confession also ukta samayre se gadi ti mu
to use the driver of the vehicle.
This owner this present petitioner, he is the owner cum driver, and his confession that samayre mu gadi chalo.
All right. As requested by Sri Das, Learned Counsel for the petitioner, is this matter in the week commencing 29th April.
Item 113. May I please, my lords? 302 is the offense, my lords, says inside custody from 24/6/23, and in time charge sheet has been submitted. My lord, the allegation is that the deceased is having his mother, my lords, and there is a quarrel between the mother and the son, and the son asked that
I paid you 1,000 rupees and what you want with that? So if it is denied, then he on the intoxicated condition throw a stone to the mothers. And then he succumbed to injury on the hospital.
କେବେ ତ question ଅଛନ୍ତି?
I mean 24/6/23.
ଭ୍ୟାକେସନ ପରେ ଆସୁ ଦେଖିବା ବର୍ଷେ ରହୁ ତାପରେ ଦେଖିବା ଭ୍ୟାକେସନ ମାଆକୁ ମାରିଦେଇଛି ନିଜ ମାଆକୁ ମାରିଦେଇଛି ମଦ ପିଇବା ପାଇଁ ପଇସା ଆଜ୍ଞା I'll tell you why.
I'm agree.
No. I'll tell you why. This will send a very bad signal to the society. That is why I'm
Married, sir. I'm agree. Let it come on after.
List this matter 1 week after. List this matter when moved. So you will make a motion after the vacation.
Married.
Item 114.
What is the connected matter? Connected matter?
I have no.
Oh, sorry. Oh. Yes, in your case.
There are two applications, one by the principal, another by the person who has given allegedly shelter to both the principal accused.
FIR ଗୋଟେ ମିଳିବ FIR ଟା ଗୋଟେ ଦେଇଦେଲେ କେମିତି ହୁଅନ୍ତା ଯଦି ମ୍ୟାଣ୍ଡେଟରି ନୁହେଁ କିନ୍ତୁ ଗୋଟେ ଦେଇଦେଲେ କେମିତି ଗୋଟେ ଭଲ ହୁଅନ୍ତା ବୋଲି ଭାବୁଛି
ଏବେ ଯୋଉଟା ଫାଇଲ
ନାଇଁ ସେ କଣ କି ଆମେ ଟିକେ ଦେଖିଲେ ଜାଣନ୍ତୁ କଣ ଆପଣ ରିଜେକ୍ସନ ବୁଝି ମୁଁ ତ ବୁଝିପାରୁନି କଣ କରିବି 376 ନୋଟିସ ଯିବ କଣ ଗାଡି ଯାଇଛି
ସବୁ ଯାଇଛି।
Interim bail.
Man of Uttar Pradesh.
Yes, sir, interim bail.
He's a man of Uttar Pradesh.
Yes.
Oh,
Yep. Yep.
list one moved. Yes.
Item 122.
Well, let it.
List one moved. क्या उत्तर प्रदेश में लोग
Interim order.
Item 122. Yes, anybody? Please.
My lord,
My lord, this is a case under section 395, 458, IPC reduced to 25.7 answer. Occurrence took place on
Where is the case?
second August of 2023 at about 7:30 PM to 8:30 PM. My lord, in this case, there was an allegation of rupees 3 lakh in a fair first time, and after 2 to 3 days, it has been changed the version that there is a huge quantity of rupees has been committed docket. In this case, this petitioner has been.
What is the name of the petitioner?
Ajmer Ali.
Ajmer, alias Raja.
1 lakh rupees has been seized
From him.
possession of this petitioner, who is in the.
What about the co-accused persons?
Other co-accused persons are there.
They are in custody.
Remain in custody.
No, they are full-fledged dockets. They have
Yes,
two
ma'am.
pistols, knife,
Course of investigation, 1 crore 68 lakhs.
No, I will not.
Has been recovered.
No, I will not grant that.
My lord, this is the specific allegation
No,
against this
no.
petitioner.
Enough evidence is there. I've seen the rejection order and I find that enough evidence is there. The court below has rightly considered the evidence and rejected the bail application, and I'm also going to reject it. The petitioner is in custody since
27th August.
27/8/2023 in connection with such and such case. It is alleged that on 2/8/2023, in between 7:30 to 8 PM, when the informant and his son were present at home, some persons entered into the house with guns and knives by representing themselves as CBI staff. They locked the informant and his son inside the kitchen on the point of gun, and also closed their mouths by sellotapes and tied their hands. One of the culprits guarded the captives while others entered into the bedroom and took away gold ornaments, mobile phones, cash of rupees 3 lakhs from the house. In course of investigation, huge amount of money was found from the possession of each of the culprits, including the petitioner. That apart, several other incriminating materials like weapons, including pistols, were also recovered from their possession. This court therefore finds that, prima facie finds that finds evidence of the involvement of the petitioner in the alleged occurrence. Looking at the gravity of the allegations, I am not inclined to allow the prayer for bail, which is therefore rejected. Yes.
Item 123.
my lord. My lord, our case has been skipped.
My
My lord.
case. My case has been charge sheeted.
123 ଆପଣ କହୁଥିଲେ ପରେ ମିଶେଇ 117 ସହିତ ନା?
My lord, 123 my lord taken up first.
ହଁ ମୁଁ ସେଇଟା ବି ଖୋଲି ଦଉଛି, ଦିଟା ଖୋଲିକି ରଖିବା ଆଉ। This is Keshav Maji.
My lord, case so much.
Yes, Mr. Behra, what is this?
My lord, case has been charge sheeted for the offence orders of 376B
Calculation scheme, my lord. And 6
Okay.
of the PID Act. And also, my lord, 66 C of the IT Act.
What is the allegation?
Allegation is that relating to the cryptocurrency, my lord.
I'm hearing another cryptocurrency matter.
No, and your lordship will kindly see the charge sheet. Not a single pie have been deposited in the account of the petitioner.
So what is the allegation against you? I want to know.
Well, I have only, my lord, encouraged the investor to keep that money in the
Cryptocurrency.
Again.
The same matter I'm hearing. Same matter, exactly same matter I'm hearing.
Besides that,
Mr. Milan Kanu is arguing that matter. He was referring to a judgment of the Supreme Court.
Supreme Court.
So why don't we take it up along with that matter? Same matter. There, the accused was also alleged to have lured other persons to invest in cryptocurrency. Whether the same thing. I think Mr. 16th, who was arguing. No, Mr. Kanu, but who was the Mr. Patra was arguing. Yes, Mr. Patra. Okay.
Account भी गोटे नुआ पैसा
ठीक है, सेटा तो हम मेरिट को जीवा. But since the allegation, basic allegation against you appears to be the same, identical. What is same? Identical. That you being an agent, you lured the person to invest in cryptocurrency. He met with a loss, therefore he lodged an FIR. And from that, many other things came out. So he was actually he is relying upon, and that day the lady IO was also present. She made certain submission. I asked her certain questions. She has requested for some time to reply to those questions. Isn't it? I think Mr. Patra was there. They couldn't answer my question.
Those two questions that we answered.
Yes. Yeah, how that attribute criminality to this person? If somebody suggests, like every day we are seeing gaming apps in the television, it comes with a rider.
Risk possibility.
That there are risks, you have to play with care. But if somebody plays and suffers a loss, then will the TV ad person be responsible? Almost. या भीतर डीप को जाए तब देखिए पूरा कौन हिच नॉइच आपन इन्वॉल्वमेंट कौन व्हाट इज योर
सेति की तो व्हाट योर लॉर्डशिप हैज observed that is the only
and Mr. Kanungo was also relying upon a judgment of the Supreme Court.
No, I have not brought, but I have taken my note. That is Ganesh Shiv Kumar versus so and so.
No.
Indian internet.
Oh, Justice Ankara. Nariman Ankara. 2020 SC.
Probably.
2020
Internet, yes, that judgment.
Madam.
So, all right, we'll call this in the week commencing 15th. So please keep watch. The number may be, I mean, the serial number may be different. So I want this matter to be taken up along with that. Is the IO the same? Lady IO. You call the IO on that day. I will not pass any order. You just call that IO. Heard in part, list this matter in the week commencing 15th April. So that on 16th it will be taken up. You make a mention.
Along with my lord, along the another co-accused in similar footing, my lord. That is PLA number 14599 of 23.
14599 of 2023.
Not
along with function. Yes.
2020 volume 10 SCC.
देखिए ऐसे मोटा
Say college, I have gone through that decision.
Then 125.
Well, 125 one application disposed of by Honorable Justice A.K. Mahabir. Then bail application number 253920.
इसे किसी interim bail नहीं था क्या करो? So why did this matter come to me?
It is in serial my lord come.
No, serial ले लो कि first type of first aid से सिटी की जरूरत था ना?
That is disposed of later. Now, in 24, my lord, that is.
No, all right. Earlier application by this.
This is the earlier. This is the first application. Thereafter,
from the same FIR, some other accused persons may have.
My lord.
I find there are quite Monglu Paska.
My lord. That was.
Purno Kudukaka.
Monglu disposed of.
Monglu disposed of by Justice Aditya Mahapatra.
My lord.
That Purno also disposed of by Justice Mahapatra. Raja Karloka.
Purno pending.
Purno is pending.
My lord.
Purno is this matter.
No, man. This is
Mala.
Mala.
Okay. Raja by Justice Mahapatra.
My lord.
No, that is also pending. All the applications are pending.
Pending, except 2539.
From the FIR details enclosed. Under flag D, it appears that the earliest bail application arising out of the same FIR was disposed of by Honorable Sri Justice Aditya Kumar Mahapatra. Stop. Registry to do the needful with kind permission of Honorable the Chief Justice. Yes. Kadam. Passout ako. Kordina nawa passout jiwa. Pala bhalo kata gote ketara achi? 25 টা 25 টা সব Yes. দেখো ketara.
Passout item number 3.
Item 3. None appears next week.
Week commencing
week commencing तुम कर दो.
Passout item number 8.
Same.
Passout item number 16.
Might please your lordship. Lordship may kindly turn to page 48. Page 48.
Injured Government Sagardas
Lordship had granted interim bail, he has already surrendered.
Because of delay in trial, I granted you interim bail.
No, not delay in trial because already after 32 witnesses.
But out of only 7 out of 23 charge sheet witnesses have been examined.
No, now, but 12 witnesses have been examined.
Yeah.
I have given the copies. The Sagar is the informant.
Yes.
May I place the FIR? He has logged the FIR. Relevant person. ধরিয়ে এসেছিল আসিবা বাটরে কুনা দাস
এফআইআর আপনি দেই না থেকে
না এটা তো আমি দেইনি
He was examined at PW 8.
না 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 এফআইআরটা টিকে প্লেস করে দিন
FIR দেই না তো কপি
এফআইআর দেই না দেই
সিডি আসেনি
না আমার ফ্রেশ ফাইলটা সিডি ফেস
ওকে ও যা হোক
PW 8 and PW 10 minus 9.
302
আইয়া
30.
মার্ক করছি
এই 41 উপেন্দ্র নায়ক ভিলেজ রেঞ্জর মঙ্গল
संतोष दास ना नहीं I'm going further than that.
You are
Santosh Das.
Not named in the FIR.
Not named, but I have given the copy of the deposition. You lordship may kindly see.
এইগুলো আছে
আইয়া দেখি দেখি না ইতরে নেই পিটিশন দেখি
Main file.
পিটিশন দেখি page 31.
Yes.
He said that I was assaulted and then I ran away. But he says no, neither the charge sheet submit the medical report in respect to the Sagar Das, nor the doctor. So there is no question of any doctor being examined on that.
Why he says I know the accused person, namely Santosh, you are the only person.
No.
What about the other accused persons? Split up হয়েছে কি?
No, split up হয়নি।
তাহলে সে I know the accused person, namely Santosh Das standing in the dock. Oh, also I know the rest accused persons in this case. Oh, they appear to receive from sub-jail Kodara. So how could you be in the dock? You are on bail.
He is in jail. He must be on bail. Interim bail.
Oh, that interim bail. Acha. Rangier Bangala Sahi Bangala Sahi. I accompanied with the deceased Kalya Naik.
Page 33 para 8.
I will.
The charge sheet doesn't include the medical report. And he said that I was examined by the doctor.
Do you got the 161?
ମୋ ମାଇଲେଜ ଫ୍ରେଶ ଫାଇଭ।
अच्छा। You have the 161 of this Sagar da?
ଆଉ ସେଥିରେ ଛଡା ମୋ ପାଖରେ ଆଉ କିଛି ଯାହା ଦେଇଛି ଆପଣ।
And my lord, 3W10 is the eyewitness. He has also stated the name of the present person.
Sagar Das is the informant. He says
there is one thing. His name is not there in the FIR. Because in the FIR, he has specifically named certain persons. Puna Das, Omkar Das.
And he says that I was injured, medical report is not there.
We will like to see I would like to see the 161 because at the first instance, even though he has given an explanation. He says, I told the scribe, but the scribe did not write his name. I don't know, there is no reason why the scribe will not write his name. ନା ମୁଁ ଯୋଉମାନଙ୍କ ନାଁ କହିବି ସେମାନେ ଯଦି ସିଏ ଲେଖିଲେନି ସିଏ ତ ଭୁଲି ଯାଇଥିବେ କଣ ହେଇଥିବ ତାହେଲେ 161 ସେ କହିଥିବେ
ଆଜ୍ଞା
ସେ 161 ଟା ଦେଖିବାକୁ you have to see the ones ପାଠର କଣ କରିବା ଥାଉ ସେମିତି let this matter on in the week commencing 15th April then state council shall obtain
ଟିକେ ଏଟା କୋଦଳାରୁ
22nd April 22nd April
ଥାଉ ଆଜ୍ଞା 15ରେ ଥାଉ ଆଜ୍ଞା ଆପଣ ଇଣ୍ଟିମେଣ୍ଟ ବେଲ୍ ଦେଇଥିଲେ ସେ ହି ହାଜ ସରେଣ୍ଡର୍ଡ ଇନ୍ ଟାଇମ୍ 15ରେ ଆସୁ
ଆଣିପାରିବେନି ପୁଣି ଥରେ ଟାଇମ କାହିଁକି ହବ ବେଶୀ ଟଙ୍କା ହେଇଯିବ 22 ତାରିଖ ଭିତରେ ହେଲେ ସେ ନେଇ ଆସିବ state council shall obtain the case diary positively yes
Pastor Act No 23.
May I please, your lordship? My lord, in this case, due to a vehicular accident, there is a blockage in the road. The present accused persons are protesting due to that accident.
Similar file?
My lord, I am, my lord, I am giving the orders. Who accused bail.
Same order.
Obvious.
Copy of the
Pastor Act No 31.
May I please, your lordship? Manner of offense under 371, 354, 536 IPC. Manner of custody bar no equus relani. It's son of a board of Zala victim. Victim is 17 years my lord.
87 both the matters were taken up. ଆଉ ଫାଷ୍ଟ ପେଜଟା ମଧ୍ୟ ଦିଆଯାଇଛି ଦୁଇଟା ଅର୍ଡରର ଏଇ ଯୋଉ synopsis cost type. It is not separately deposit, it is both the cases taken up together. That is what we are given to understand also by our advocate from Supreme Court also.
କଣ କରିବା ଇଏ ତ ଟିକେ ଗ୍ରେ ଏରିଆ ରହିଯାଉଛି।
First page you lots of them. Entire description is there. Miss case number 721 2017.
No, I'm not on that. I'm saying whether this order covers both the cases or
दुईटा जगह case SLP number अछि. Both the SLPs are there. Appeal number, sorry, criminal appeal number 878, 879.
just examine it. I'll dictate the order after I come back. Just examine it. Mr. Sorry, I'll dictate the order after I come back again. After recess.
Again.
Huh?
My
No, you have to be there. You have to be there because of the importance of this decision. I want to just give a chance to the state council. Let him also go through. Let him apply his mind. Right. That's why That is why it will be better if you there because this is a heavy matter. So
yes, sir.
This will be the first case I'll take up. I'll dictate the order. I'll narrate all the facts. That is Supreme Court has passed such and such order. So I can dictate it.
Okay, Lord. After recess,
yeah. After that matter, or put the put it on.
This is there.
One order.
In both the matters, you will also pass common order that to deposit 7.
Okay. So the petitioner is the same.
Petition is the same. Opposite, but he also information also same.
No, but the case must be different.
The case numbers will increase also.
Right.
First is 9130.
Both these bail applications are being disposed of by this common order. As they have been filed by the same person. Stop. In BLAPL number 9130 of 2023, the petitioner is in custody in connection with
PS case, PS case number.
City case number. City case number. City case number
574 of
2014 of the Court of Learned CJM, come Assistant Sessions Judge Nuapada, for the alleged commission of offences under sections 420, 468, 471, 409 IPC.
120B.
120B. That's a 120B IPC. In BLAPL number 9129 of 2023, the same petitioner is in custody. Either custody the same.
Same, sir.
Custody in connection with city case number 320 of 2014 of the Court of Learned CJM Nuapada.
Same
of the commission of the offences under section 409, 420, 468, 471, 120B IPC. Para. Originally, the petitioner was granted bail by this court in BLAPL number 1188 of 2016 by the order dated 5/8/2016 in relation to city case number 574 of 2014 on the ground of on the condition of furnishing cash security of rupees 1 lakh inter alia on the condition of furnishing cash security of rupees 1 crore. Aratar kon hitla?
Aratar se aitala.
Similar order
खाली
passed.
city number टा change हो
was passed
city number टा कितने
in
320
314
1186 of 2016
no sir, the bail order. I need the bail order.
bail order
186
1186 रसा दिल्ली
Chief Justice J.P. Das was it?
Sir.
Similar order was also passed in relation to CT case number 320 of 2014 by this court in BLPL number 1186 of 2016 by the order dated 5/8/2016. Then you went to the Supreme Court.
No, we got the order modified. Got it extended from time to time.
Modified by this court?
By this court. Same court, your lordship.
Yes. Modified to the extent?
To the extent that we are not able to deposit the money so that it be substituted by property security. Your lordship was pleased to grant us that liberty, but for 3 months only. Then thereafter you substitute the case security. That is how the 3 months we are there. So the lordship said we have, because that order we also challenged.
So we'll go to the Supreme Court directly.
Let us go to Supreme directly.
The petitioner approached this petitioner approached the Supreme Court by filing criminal appeal numbers 878 and 879 of 2018, primarily seeking modification of the condition to deposit ₹1 crore towards cash security stock. By order dated 13/7/2018, passed in criminal appeal number 878-879 of 2018, bracket re, arising out of SLP, bracket re, CRL numbers 5728-5729 of 2017, the Supreme Court directed that on deposit of ₹75 lakhs, the petitioner shall continue to remain on bail and on non-compliance, the bail shall stand cancelled.
Your lordship may turn that order to the last page. Both the appeals are disposed of.
Yes.
Further,
the amount being deposited shall be invested in fixed deposit. With these directions, both the criminal appeals were disposed of. You did not deposit.
You did not deposit, absconded. Thereafter, warrant of arrest was issued. That is the order impugned.
The petitioner did not comply with such order and absconded, for which non-bailable warrants of arrest were issued against her in both the cases.
Arrested on 18/2023.
Ultimately, pursuant to such NBWs, the petitioner was arrested
on 18/6/2023
and taken to custody on 18/6/2023. Sorry. Sri S.K. Sodangil and senior counsel appearing with Mr. Ajit Kumar Mahanti would argue that that because of stringent financial condition, because of financial stringency, the amount could not be amount as directed by the Supreme Court could not be arranged for being deposited. Stop. However, the petitioner is now ready and willing to deposit the amount of ₹75,000 as directed by the Supreme Court, provided some time is granted.
75 lakhs, not 1,000.
Sorry, 75 lakhs. Correction. 75 lakhs. Sri S.K. Mishra, State Counsel, submits that no further indulgence should be granted to the petitioner, since she has not complied with the order passed by the Supreme Court. So how much time do you need?
15. On deposit.
On deposit, your lordship.
On deposit hele kintu. DW has already been, money you have been taken to custody. Na? You are in custody. So we'll have to fix a period.
15 दिन.
15 दिन. Considering the, having heard learned counsel for the parties and on going through the case record, this court is of the view that considering the merits of the case, the coordinate bench of this court had granted bail to the petitioner. Though, granted bail to the petitioner, albeit subject to certain conditions. Stop. The condition of depositing rupees 1 crore in each of the cases has subsequently been modified by the Supreme Court in the aforementioned criminal appeals. Stop. The petitioner, being a lady, has been in custody for 7 months for nearly 10 months. Moreover, she is ready and willing to deposit the amount as directed by the Supreme Court. Under such circumstances, her further detention in custody would inure to the benefit of no one. The bail application is therefore allowed. Bail applications are therefore allowed. Let the petitioner be released on bail, subject to the condition that she shall deposit rupees 75 lakhs as directed by the Supreme Court. Prior to such deposit, when will you make the deposit?
Within 10 days.
15 days.
15 days.
15 days from the date of release.
No. I am saying
Next 15 days after your lordship releases me, I will deposit the amount within 15 days. Yeah,
So after release, the order has been.
Sir, ठीक अछि, then
after depositing maybe.
After deposit, subject to subject to depositing कौन लिखले? कौन है मूल टिके ता गोटे लाइन मूल में अधिक आधार पर लेके बुझियो. Subject to the condition that she shall deposit lakhs in the code below. In the code below. है comma, which shall be kept in fixed deposit in any nationalized bank. See, कौन लिखते हैं? In any nationalized bank being placed to the court.
being placed.
That's all. So the moment you deposit, you will be released. I will say, why will I say 15 days or 10 days?
ठीक अछि.
As long it is in your interest to deposit as early as possible. But sir, are you sure that this is not in respect of two separate 75 हवन तो?
Sir, both the appeals are disposed of last को लिखले बरा.
तो कथा बुझी पड़छुं.
हमें सफर करियो ना.
कनेक्ट दिता मिसिंग
तो इसी गोटे ऑर्डर हबो नहले सेटा कोन इंडिकेट करा हबो.
Then move प्रथम देखिले ना first paragraph. Both these cases are taken up together.
That your lordship has said. तोड़ को कंफ्यूज होने चांस नहीं तो फिर जे.
No, I have said 75 lakhs. Both the cases are deposited.
In total कर दो.
हाँ, rupees 75 lakhs in all.
अरे सेटा कर देली in compliance of Supreme Court order ताले
in compliance of the order.
नहीं सेटा.
And please advise your conducting counsel to enclose also a copy of the Supreme Court order along with the bill application. So that you never know, court may feel a little bit different.
ये बोले सर रिफ्लेक्ट करछंती ये रे इम्प्यून ऑर्डर रे रिजेक्शन ऑर्डर अछि बोले.
जैसे कहीं जे तो डिपॉजिट कले नहीं बोली. लेट मी सी.
हां बोधे अछि लेकिन रिजेक्शन ऑर्डर
Case 42 रे.
For the first case.
First case. Case 42.
हाँ sir, page 42 रे अछि. It is stated that the appellant to deposit a sum of rupees 75 lakh
by 3rd October.
By 3rd October such and such. Accordingly, the order passed by the High Court is modified.
मैं सीधे पर ऐसे जो ऑर्डर पूरा कोर्ट को दीजिए.
कोर्ट को दीजिए. जब तक से कंफ्यूजन हो नहीं. Anyway, we will take care of that.
Yes.
So right number 46.
Offense under section 420, 468, 470 and 120 BIPC. And section 456 of exciting money circulation in custody for more than 1 year. And last time, High Court has directed take instruction what is the exact amount which has been credited to the account of the parent.
FIR copy.
Serious, almost it's not FIR copy nahi. Yes, I've got the.
Yes, what is the, Mr. Naik?
So far the amount is concerned to the petitioner's company account, 11 crores 37 lakhs 58,000 has been credited.
Petitioner's company's account.
Company's account, petitioner is the authorized signatory.
Yes.
Messrs. Hakim Rustam Fabric Private Limited. What happened, Miller? There is 18football.com, a website was created by some of the co-accused. That using that app, they were collecting the money and giving the link that the investor will deposit in that link. The accused persons used various accounts in AK Traders, petitioner's account, and the petitioner's account by this process. In the petitioner's account, 11 crores 37 lakhs has been deposited by the investors.
Yes. Then
and both petitioners have the authorized signatory. That Hakim, Messrs. Hakim and Rustam Fabrics Private Limited.
you know the judgment of the Supreme Court in these cases. Very difficult to get bail.
So, my humble submission, to attack the offense under section 420, the ingredients of 415 must be there. The very initiation, the
intention to give.
As in the particular case, the investors, they have also given some sort of interest for some years, some period. It's true that in the latter part, the money has not been paid. So my humble submission, when the money has been, interest has been paid to the investors, right at the initial stage, it will continue for a particular period. And because of the fact that, because of some reason, the business or the money where the money which was invested by the petitioners, not exactly petitioners, other persons were there. The petitioners are the small prey, they will get into the, because of their poverty, while they get into society and they have been looted by the other persons. But remember, that is not a subject matter because I cannot put forth this, although even if I put forth, I can prove the same right at this moment. But that is a fact. But the fact remains that I have the company, they have given money to those persons at the initial stage. At the later part, the money which has been invested, it has not been brought out. And in the process, we have not been able to pay the money to the investors. So by the process, cheating is not there.
Okay. But then section 4, 5 and 6 of the Price Cheats Act will be attracted because once you promise them of some returns and accept deposits, then that act comes into picture.
And 6 OPA Act.
6 OPA Act, Prakuji, say you have the charge sheet. I would like to go through the charge sheet. What is the exact material against him? Only because he is an authorized signatory does not mean that he will be responsible.
Petitioners who have the signatory. And in their account, 11 crores have been.
In their account means in their company's account?
Company's account.
Personal account.
Company's account and some amount out of that has gone to the personal account.
So that I would like to know what is the amount that has gone to their personal account, number one. Number two.
And it is a cell company. During investigation, it was found it is cell company was prepared, was registered for the purpose of utilizing their account in this app.
No, Mr. Naik, what is the has any amount been secured?
No, the account, no.
Please,
account is not. No, account freeze.
It is in Calcutta. Account is in Calcutta. And balance is nil.
Balance is nil. Have you seen? You file a copy of the charge sheet and file along with the charge sheet. Charge sheet we are asked to see what is the role, and I will also ask him to take instruction with regard to the specific role played by the petitioner. Is he the only person?
No, several accused persons have it.
Here only 2 persons have come.
Yes.
You have a copy of the charge sheet, Mr. Chan? Why don't you file a copy of the FIR charge sheet? See,
hard copy or hard copy or
hard copy? 2023 or hard copy 2023?
Yes.
Maybe hard copy. उनके 4 concept of the petitioner files copies of the FIR, charge sheet and other documents. Same be kept on record. Sri Naik, Learning Council appearing for the state and OPID matters is directed to take instructions as to the specific role played by the petitioner in the petitioners in the alleged occurrence and their personal liability, if any, to the investors. That's is this matter in the week commencing
29th April.
29th April.
So right now 49.
1 week after.
1 week after.
So right now 51.
Yes, Chaddev. None appears. None appears. Should I pay now? Then none appears next speaker though.
So right now 52.
Yes.
Occurrence took place on 17/11/2022, my lord. Initial one UD case was registered, my lord.
Yes.
Therefore, turned to FIR on 21/11/22, petition taken into custody for 24/11/2022, my lord. Only allegation against the petitioner of basing on confidential statement and one recovery of shoe of the deceased from the spot. That effort, there is no allegation against the present petitioner, my lord.
Yes. My lord, that reason is that she is suspecting, petitioner suspected that the deceased has a love relationship with another person.
Yeah, what is the relationship between the petitioner and the deceased?
But he also
Not a love relationship.
and PM report is that is strangulation. And the minor child with whom the deceased has gone to bus stand, his 164 statement was recorded. It may be treated as a last seen treatment. And once so it was a cover and vanity bag and mobile, it was thrown to the water, to the running water. So it could not be recovered. The 164 statement, my lord.
Yes.
The minor child he has stated ଯେ ମୋ ଭଉଣୀ ମୋ ସହିତ ମୁଁ ବଡ଼ବିଲ ବସ ଷ୍ଟାଣ୍ଡ ଯାଇଥିଲି ସେଠାରେ ମୋ ଭଉଣୀ ଓ ତାର ଲଭର ଦ୍ୟାଟ ଇଜ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଅରୁଣ କୁମାର ମହନ୍ତ ଦେଖା ହେବା ପାଇଁ ଯାଇଥିଲେ ସେଠାରେ ଅରୁଣ ମୋ ଭଉଣୀକୁ କିଛି ପଇସା ଦେବା ପାଇଁ ଡାକିଥିଲା କିଛି ସମୟ ରହିବା ପରେ ମୋ ଭଉଣୀ କହିବା ଅନୁସାରେ ମୁଁ ଟ୍ୟୁସନ ଯିବା ପାଇଁ ସେଠାରୁ ଫେରି ଆସିଲି ହେଲେ ସେଇ ସନ୍ଧ୍ୟାରେ ଭଉଣୀ ଘରକୁ ଫେରି ନଥିଲା ତେଣୁ ମୋ ବାପା ବ୍ୟସ୍ତ ହୋଇ ମୋତେ ଭଉଣୀକୁ ଫୋନ କରି ତାର ଠିକଣା ବିଷୟରେ ପଚାରିବା ପାଇଁ କହିଥିଲେ ବାପାଙ୍କ କହିବା ଅନୁସାରେ ମୁଁ ଫୋନ ଲଗେଇଥିଲି ହେଲେ ସେ ଫୋନ ପ୍ରଥମେ ନଟ୍ ରିଚେବଲ ତାପରେ ସୁଇଚଡ ଅଫ୍ ଦେଖା ଦେଇଥିଲା ସେଇ ରାତି ଭଉଣୀ ଘରକୁ ଫେରି ନଥିଲା ତା ପରଦିନ ସକାଳେ
ଭଉଣୀକୁ କୋଉଠି ଛାଡିଲା ବସ ଷ୍ଟାଣ୍ଡ କୁ ଯାଇଥିଲି
ବସ ଷ୍ଟାଣ୍ଡରେ ଛାଡିଥିଲା ବସ ଷ୍ଟାଣ୍ଡ ସାଙ୍ଗରେ ଦିସ୍ ହାଜ ଗନ୍ ୱିଥ୍ ଦ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର
ଓକେ
ତା ପରଦିନ ସକାଳେ ବାପା ଭଉଣୀକୁ ଖୋଜିବା ପାଇଁ ଚେଷ୍ଟା କଲେ କିନ୍ତୁ ପରେ ତାଙ୍କ କାମରେ ବ୍ୟସ୍ତ ହୋଇ ପଳାଇଥିଲେ ମୁଁ ମଧ୍ୟ ITI କୁ ପଳାଇଥିଲି ସେହି ଦିନ 2:04 ସମୟରେ ଆମ ସାହିର ଲୋକମାନେ ଆସି ମୋ ମାଆକୁ ଜଣାଇଥିଲେ ଯେ ମୋ ଭଉଣୀ ମନୀଷା ମହନ୍ତର ମୃତ ଶରୀର ହାରପୁର ଜଙ୍ଗଲର ଏକ କେନ୍ଦୁ ଗଛରେ ଲଟକି ଝୁଲିଛି ଏହା ଶୁଣି ମୋର ମା ଚେତା ହରାଇ ବସିଲେ ଏହାପରେ ଏକଥା ମୋ ବାପାଙ୍କୁ ଜଣାଇଲା ପରେ ସେହି ରାତିରେ ଅରୁଣ କୁମାର ମହାନ୍ତିକୁ ପୋଲିସ ଗିରଫ କରି ନେଇଥିଲା ଓ ତାପରେ ଦିନ ସକାଳେ ଆମକୁ ଥାନାକୁ ଡକା ହେଇଥିଲା ଆମ ସ୍ଥିତିରେ ଅରୁଣ ମହାନ୍ତି ପୋଲିସ ଥାନାରେ ତାର ଦୋଷ ସ୍ୱୀକାର କରି କହିଲା ଯେ ସେ ମୋ ଭଉଣୀକୁ କୌଣସି ଅନ୍ୟ ପୁରୁଷ ସଙ୍ଗରେ ସମ୍ପର୍କ ରଖିଥିବା ସନ୍ଦେହରେ ଜଙ୍ଗଲକୁ ନେଇଯାଇଥିଲେ ସେଠାରେ ଉଭୟ ମଧ୍ୟରେ ଝଗଡା ହେଲା ଏବଂ ରାଗରେ ଆସି ଅରୁଣ ମହାନ୍ତି ଚାପୁଡା ମାରିଥିଲା ଯାହା ଯୋଗୁ ସେ ତଳେ ପଡି ଯାଇଥିଲା ଏହାପରେ ସେ ତଣ୍ଟି ଚିପି ତାକୁ ହତ୍ୟା କରିଦେଇଥିଲେ
ତଣ୍ଟି ଚିପିବାର ପୋଷ୍ଟମର୍ଟମ କଣ ଅଛି
ଷ୍ଟ୍ରାଙ୍ଗୁଲେସନ ଇଜ ଦେୟାର ମ୍ୟାମ୍ ଦେଖେ
Hello, same person, my lord. Same, in a 161 statement.
What a minute, let me see the postmortem, then I will go to you.
My lord, PM cause of death is asphyxia due to strangulation.
Due to strangulation.
My lord. And there is some external injuries, there is some abrasion over some part of the body, my lord.
So death by throttling, throtti chipping.
बाय स्ट्रांगुलेशन हाँ चक मारिकी से जो ओनी रे हाँ से ओनीटा टांगी देथिला गछरे but it was not suicidal it is strangulation.
Then what other evidence apart from the confession? 27 is there.
27 is there, that is only that shoe of the deceased was found. Other vanity bag and mobile, it was thrown to the running water.
No. 27, did this person lead the police to the recovery of the
Yes,
shoe?
my lord.
What did he say? What is that particular statement? What does he say?
आज को रिलीवेंट पार्ट मैडम आज को प्राय 3 वर्ष है मनीष महंत को भल पाउली मनीषार श्वास रोग थिला जहा को विभिन्न जगह
किछि एडमिसिबल नुहे एटा किछि एडमिसिबल केवल सेही पर्सन ता
मैडम मनीषा मते टंका मागितला जहा फल आम मते झगड़ा हला या पर मो मनीषा को बारंबार पचारे से मते से कथा देउतबा पिलार नाम कहला नै जहा फल मोर राग बढ़ी गला मु ताकू मोर पासन प्रो मोटरसाइकिल जार नंबर 100 बसाय हरेपुर जंगल को नेली बाटर गला बेले से पार्टी करथुवार किछि लोक सुनिचंदी जंगल रास्ता रे एक निछाटिया जगह गाड़ी रखी सेटा छिडा हलु मु सेही समय मु रागरे तार कान मूल को एक चापुड़ा मारली से तळे पड़ी गला और तार गला को दबाई हत्या करली से एक चदर घोड़ाई होइथिबारु तार हाथ बाहर करि पारली नाही और दोष लुचाई को मनीषार चादर ए जो स्टॉल जोटा मोरे बांध रे बेको को बांधी एक गछरे तार मृत शरीर को टांगी देली मो मनीषार चप्पल को किछि दूर रे फिंगिछि और भैनिटी और इंडस्ट्री बैंक बैग को पाखरे फिंगी देछि तार मोबाइल फोन को गाड़ा हटिंग पाखरे थिबा नळा रे फिंगी देछि मो सहित आपण मान गले मु फिंगी थिबा मनीषार चप्पल भैनिटी बैग मोबाइल फोन को बाहर कर दे बट मोबाइल फोन एंड भैनिटी वाज नॉट रिकवर्ड ओनली दैट शू वाज
ethical evidence.
Yes, so far the recovery recovery the shoe from the spot manner. And so far as 160 post statement in 160
recovery shoot from the spot put varla. Put is the list kain?
The list
only from where
the same manner spot was Hayapur jungle.
No, सही जगह spot of occurrences are totally different. The entire thing may be a jungle. But जो जगह से
सेटा से भी हायरपुर जंगल ये भी देखा जाए
हायरपुर जंगल तो is a big area. That is not the spot.
Yes.
Spot is in the हायरपुर जंगल.
कर लिखा है जी
ना सेटा होने anyway. तापरे आओ कौन
164 statement the same brought the same person matter. He stated that मो नाम से मो थाना वो मते डाकिले थाना को थानार अटक थे आसामी अरुण कुमार महंती पिता सोहनसो तांको उपस्थित दोष स्वीकार करे ही द कॉन्फिडेंस स्टेटमेंट विटनेस टू कॉन्फिडेंस स्टेटमेंट
this is a confessional statement that is all
सेटा तापर सेटा
no he said that his role is only is limited only to that to prove that last scene theory. He had gone with his sister to the bus stand from where the petitioner took his sister to another.
Say 161 सेटा कोनी से
नहीं सीधा 161 कौन कहउछन
161 जे मते आज ये काम बड़बिल थाना को आस्थिल थाना आईआई सर मते मनीषा मात्र मर्डर के साक्षी रहयो कहबार मु सेते राजी हेली थाना अटक थे आसामी अरुण कुमार महतो बयस 30 सोहनसो तांक अटक थे आम उपस्थित तार दोष स्वीकार कहले जे that is therefore स्वीकार कर गले श्री रंगलता 15 पुओ छै सकाळ प्राय 3 वर्ष मनीषा महतो भलो
नहीं छाड़ दंतु सीता जीवा कथा कहनी नो अपन तार आउट स्टेटमेंट थिबो
दीटा कहि ना सेइत्र भी से कहि छी एत्र 164 भी से कहला फास्ट कहला जे द लास्ट इन थ्योरी ते मु जाइतली बस स्टैंड को तापर से माने सांग होई गले पुलिस धरिला परे मु थाना को डाकिला मते पचारिले मु ताको कहली बोली सो 161 भी से 164 भी सेम जिंस कहि छी सो
161 सेटा नाही
What is his name?
अरुण कुमार जो
अरुण जे कहला 164 जार अपन पढिले
से 161 से
हरीश चंद्र महंत
लेकिन 161 ता से स्टेटमेंट टोटल नाही
हां कहि छै ना थाना रे
ना से 164 लेकिन 161
Has he improved? Find out from 161 to 164.
मतलब 161 ने जे अरुण कुमार महंत आम उपस्थित दोष स्वीकार कहला कि तार स्त्री रंगलता 15 वर्ष पुओ अछि आज प्राय 3 वर्ष मनीष महंत भल पाउथला मनीषर श्वास रोग थिला ताको विभिन्न देखा देखा भल कि जास कहितला से जो लीडिंग डिजीज को सेगुडा कहला अत आज କିଛି ଦିନ ତଳେ ମନୀଷା ଅନ୍ୟ ପୁଅ ସହିତ ମାର୍କେଟରେ ବୁଲୁଥିବାର ଦେଖି ତାର ସନ୍ଦେହ ବଢି ଯାଇଥିଲା, ଯେଉଁଥିପାଇଁ 18/11/22 ମନୀଷା ତାକୁ ଦେଖା କରିବା ପାଇଁ ସନ୍ଧ୍ୟା 6:30ରେ ଡାକିଥିଲା। ସେମାନେ ବଡବିଲ ପୁରୁଣା ବସଷ୍ଟାଣ୍ଡରେ ଦେଖା ହେଲେ। ସେମାନେ ଏକ ଦୋକାନରେ ରୋଲ ଖାଇଲେ। ମନୀଷା ତାକୁ ଟଙ୍କା ମାଗିଲା, ଯାହା ଫଳରେ ସେମାନଙ୍କ ସହ ଝଗଡା ହେଲା। ଏହାପରେ ମନୀଷାକୁ ତାହାର ପାସନ ପ୍ରୋ ସାଇକେଲରେ ମୋଟର ସାଇକେଲରେ ଓଡି ନମ୍ବର 1600 ବସାଇ ଚମ୍ପୁଆ ଗଲେ। ଏଠାରେ ଏକ ଦୋକାନରେ ଚାହା ପିଇଲେ। ତାପରେ ବାଟରେ ମନୀଷାକୁ ବାରମ୍ବାର ସେ ପିଲା ବିଷୟରେ ପଚାରିଲେ। ମନୀଷା କିଛି କହିଲା ନାହିଁ। ସେମାନେ ସେଠୁ ଫେରି ମନୀଷାର ଘର ବାଟ ଦେଇ ହୟାରପୁର ଜଙ୍ଗଲକୁ ନେଇଗଲା। ବାଟରେ ଗଲାବେଳେ ସେ ପାର୍ଟି କରୁଥାଏ, ଯାହା ଅଛି ସେଗୁଡା ସେ 164
ବସଷ୍ଟାଣ୍ଡରେ ଛାଡିବା କଥା ନାହିଁ।
ନାଇଁ 161 ସେ ଆଉ କହିନି ଯେ ଆଇ ହ୍ୟାଡ ଗନ୍ ୱିଥ ଦ ଡିସିଜ୍ଡ।
କ୍ଲିୟର ଇମ୍ପ୍ରୁଭମେଣ୍ଟ
କିନ୍ତୁ କହିଛି।
କ୍ଲିୟର ଇମ୍ପ୍ରୁଭମେଣ୍ଟ ହେଇଯାଉଛି। ତାପରେ ଦି ମ୍ୟାନର ଅଫ ହି ମେ ହାଭ possible that some other person was also involved.
Well, actually, there was love relationship. Their family members also known that the deceased and
Because Mr. Mishra, it is the way he has described how he killed. It is not possible. The person will not try to save herself. And he will just give a slap and the lady will fall down on the ground and he will try to, and he will immediately be successful in strangulating her and then lifting her body and tying it with that oroni.
Yes.
Is that oroni strong enough to withstand the weight of her body? It seems rather far-fetched. Find out further evidence କଣ this.
ନାଇଁ ସେତିକି ଅଛି, ଆଉ ଦେଖୁଛି ନାହିଁ। ମୁଁ ଚେକ୍ କରୁଥିଲି whether that is that chuni is sufficient to ସେଟା କିନ୍ତୁ ଆସିନି।
No. So the way he has described seems a little bit difficult to believe. If they had a quarrel and only by slapping her, she will fall on the ground and be in such a condition, such a vulnerable condition that the petitioner will be able to overpower her, throttle her, and then remove that stole and hang her from a tree. All this by himself seems rather far-fetched.
Yes. Actually that the true things has not come to the picture.
Proper investigation is necessary.
There is love relationship.
Yes, there is another person may be involved. There's a triangle here.
Yes.
All right.
Two pictures.
Since when are you in custody?
24/11/2022.
The petitioner is in custody since 24/11/2022 in connection with such and such case. It is alleged that the petitioner, despite being married for the last 15 years, had a love relationship with the informant's daughter for about 3 years. He suspected the deceased of having, she suspected her of having, subsequently, she suspected her of having a relationship with another person, for which he bore grudge against her. Stop. On the date of occurrence, the petitioner called the deceased to the bus stand and demanded to return cash of rupees 90,000. Whereupon the deceased and her brother went to the Hon'Ble bus stand. Stop. Thereafter, nothing was heard about the deceased, who was subsequently found in a nearby jungle. Stop. In course of investigation, the complicity of the petitioner having come to light, he was taken to custody. Sri P.S. Das, lawyer and counsel for the petitioner, submits that the petitioner has been implicated entirely on suspicion and that there is no evidence to show his complicity. His confessional statement before police is sought to be utilized against him, which is inadmissible in law. He further submits that the so-called last seen theory, Learned State Council, on the other hand, has opposed the prayer for bail by submitting that the prosecution not only relies upon the confessional statement of the petitioner, but also on his disclosure statement recorded in section 27 of the Evidence Act, as also the statement of the brother of the deceased, who was the last person to have seen the deceased with the petitioner before discovery of her dead body. Stop. I have heard learned counsel for the parties at length and have perused the case diary, including the statement of Harish Chandra Mahanta, brother of the deceased, recorded under section 164 of CRPC. He has stated that he had accompanied the deceased on the date of occurrence to Hon'Ble bus stand, from where the petitioner took his sister on a motorcycle. Stop. This court, however, finds that his statement as above is at variance from his earlier statement recorded under section 161 of CRPC, inasmuch as he had not stated anything therein. He had not stated anything regarding accompanying the deceased to Hon'Ble bus stand and of seeing her leave with the petitioner on his motorcycle. Stop. If the statement of Harish Chandra Mahanto is ignored, there is no other admissible evidence to connect the petitioner with the alleged occurrence. Taking into consideration all the above facts, as also the period of detention in custody, I am inclined to allow the prosecution. Let the petitioner be released. Subject to each the appearance, no representation.
Pastor item number 57.
Sir, may I please, my lords? My lords, on the last occasion, lordship have called for a status report, my lords.
Status report?
It is at flag KM.
Only one prosecution witness remains to be examined. And the cases was posted to 28/3/2024. It may have been
examined.
He may have been examined. All right. The court below has submitted a status report from which it is seen that out of 3 PR witnesses, 2 have been examined and 1 witness was to be examined on the last date of hearing. That is 28/3/2024. Stop. Learned counsel for the petitioner wants to take instructions in this regard. List this matter in the week commencing 15th.
Obliged. Pastor item number 66.
None appears. None appears for you.
Pastor item number 69.
I agree, man. Here, through that Instagram, log relationship between this petitioner and
Notice, sir.
Examine
notice, sir.
No, my lord. Notice has not been served.
Notice has not been given.
Examine
नहीं पर है notice टा यही bail application और notice टा का submission
the extra copy sort of
yes.
Last order
Not been served. But you have no instruction.
No instruction.
If you come next week, you find out.
Yes.
ମୁଁ ଆଜି ବର୍ତ୍ତମାନ ବି ଗୋଟେ ଜେରକ୍ସ କରି ତାଙ୍କୁ ଦେବି।
ନାଇଁ ନାଇଁ
କାଇଁ ଦେଇଛି ତ ସେ ତ ଅଲରେଡି ପଠେଇଛି ନା ଆଉଥରେ କାଇଁ ଦବ?
ପ୍ରିଭିୟସଲି ଗୋଟେ ଅର୍ଡର ବି ଥିଲା ସେ ଅନୁସାରେ ମୁଁ ଦେଇଛି ଅଲରେଡି।
And State Council requests for some time to inform the court to obtain instructions regarding service of notice on the victim. Place this matter in next week.
So item number 73.
Charte.
My lord,
Yes,
my lord, want to withdraw the case, my lord.
permitted to withdraw.
So item number 78.
I think the lordship. The offence alleged under section 498A 302 294 506.
You're the husband.
Petitioner is the husband.
Yes,
Husband. Custody since 30th January 2023. So far the FIR allegation is that there was previous torture to the daughter, my sister of the informant. And the last occasion, it came to know that the petitioner has killed his sister by a sharp cutting blade. That is the allegation. The matter has already been committed to the court of session.
Yes, ma'am. And his daughter has seen the occurrence. Though child witness has seen the occurrence.
8-year-old daughter.
Yeah, well.
yes. ଆଗ କହିଲା ଅବୁ ଆସିକି ଅମିର ତଣ୍ଟିକୁ ଚିପି ଦେଲା। ତାପରେ କହିଲେ ଏମିତି ସେ ଅବୁ କାହିଁ କଲେ ନା ମୁଁ ଜାଣିନି। କେମିତି ଅମିକୁ ମାରିଲେ ନା ବ୍ଲେଡ ଅମିର ତଣ୍ଟି କାଟିଦେଲେ।
এইটা আগে চিপি দেলা কହୁଛି ତାପରେ କରି କାଟିଦେଲା।
ଟ୍ରାଏଲରେ ତାକୁ ଜେରା କରୁ। ଜେରା କରୁ ତ ଆଗ ଏୟା କହୁଥିଲୁ ପୁଣି ବର୍ତ୍ତମାନ ଏୟା କହୁଛୁ ତାହେଲେ ତୁ ଜାଣିନୁ ଇତ୍ୟାଦି ଇତ୍ୟାଦି ଆପଣ ପଚାରିବୁ ଆଉ କଣ କରିବା।
ଏକ୍ସପେଡିଟ୍ ଟ୍ରାଏଲ କରିଦେଉଛି।
You take up, then withdraw it with liberty, I will say.
Yes, I am trying. Lordship may say expected the trial within a specific period. Thereafter, I will move it.
In course of hearing, learned counsel for the petitioner seeks permission to withdraw the bail application and further prays with further prayer to direct the court below to expedite the trial with liberty to renew his prayer after. To expedite the trial. Stop. Permission is granted. Stop. Further, the court below is directed to conclude the trial. 2023.
Yes, charge sheet having 23 days.
As early as possible, preferably within a period of 6 months. If it shall be open to the petitioner to renew his prayer if trial is not concluded within the stipulated period. ସେଥିରେ ବି କଣ ହବ?
ସେଇ ଆଉ କେହି ନାହିଁ ସେ ଚାଇଲ୍ଡ ୱିଟନେସ୍ ଟା
ଚାଇଲ୍ଡ ୱିଟନେସ୍ ର କନଭିକ୍ସନ।
ଆଜ୍ଞା
Item number 80.
Please, the lords. Offense under section 372 and my lords, section 6 and 4 of Poxo Act.
376 ବନ୍ଦ କର। ଆରେ 3 ତ ଥିଲା।
gone to the nearby uncle's house to participate in the Namajagya. And then return on the next day morning, he found that his brother was dead. Found dead on a lot.
Unknown affair.
Unknown affair unknown.
Yes, then what happened?
Affair unknown. Only the link is the suspicion. Totally case basing upon the suspicion. My lord.
Yes.
And the PM report is that death due to multiple cut injury and vital organs. There are 15 numbers of injuries are there. And the reason is that the accused suspecting that the present petitioner is doing witchcraft. For which is not.
What evidence?
And that leading to maybe discovered that bloodstain axe was seized from the present petitioner.
Bloodstain axe, only axe.
No. Bloodstain axe was seized from the present petitioner. And the wife of the present petitioner, he has also, it may be a last scene theory. He has seen that the present petitioner has gone to the house of the. She has gone to the. No, the present petitioner has gone to. She has seen that the present petitioner has gone to the house of the deceased.
Meanwhile, 5 witnesses are examined, my lord.
Yes. Has that lady been examined?
No.
No, madam. That lady was not examined. That informant was also not examined.
So lie over thou.
Yes, ma'am.
Lie over thou. There are two important things. 27 cannot be ignored.
My lord.
Second thing, that lady.
Wife of the.
I am not accepting motive. Because there's no evidence. And 27, you know only that recovery of that bloodstained axe will only. Has there been a cross matching of the blood?
No, it was not for that.
No.
What is not available in the
forensic laboratory.
Only if they have sent for paper. Let these two materials maybe.
I will not say anything. Why should I? It's for the trial. So this cross matching is required. What blood was found in that axe? Whether that blood belongs to the deceased or somebody else.
That I want to find from the case record, but it was not.
All right. List this matter as prayed for. List this matter in the week commencing 22nd.
My lord.
Yes. Then.
So I don't know 110.
Chalo. How many?
I don't know 116.
May I please, your lordship?
Yes.
Offense under section 20B2C of NDPS Act. Lordship accused is in custody since 5th of August 20.
Since when? Since when is he in custody?
He is in custody since 5th August 2023.
Final PR has been submitted. Final PR has been submitted.
And from Madhya Pradesh.
Madhya Pradesh?
Yes.
Lordship, my humble submission is that she is a lady and mother of 2 children. And although she is from Madhya Pradesh, any stringent terms and condition may be.
No. List this matter when moved. Yes. Next matter.
Item 119.
Chad deo.
Hello.
Yes.
I'm appearing for accused petitioner.
Yes.
Since 7th July 2023, he is under custody. The matter is totally 14 crore that both companies, iService Technology and Payment Technology, with the written agreement that the payment given by the iService Technology under QR code and Finobank fluence. But the difference between tempered by the QR code, that is undisputed because the iService Technology connected. I am giving to you via QR code, and this is the tempered between 8th June, between 9th June. My lord, I just say only one thing. If you are paying 2 crore, 10 crore, and then how to say that I am forgery? This is the section 420, 467, 420, 120, and 65, 66. Between the agreement. My lord.
You have the case diary?
Yes, madam. Case
Yes.
diary. Instruction is there. IO instruction.
No. What is the allegation against him basically?
420,
who is the petitioner is Karan Kumar Singh. No, I mean, what is the factual allegation?
Yes, yes.
What did you do? 420 is all,
420.
sir. What did you do? What is the factual allegation? Let us see the FIR.
Yes, yes. The FIR lodged by the Umakant Sahu, the opposite company, iSerview Technology, that the payment of rupees 14 crore taken by Karan Kumar Singh accused under custody since 7th July 2023. My submission is the payment of 14 crore in which 2 crore 83 lakh already recovered and the balance amount is 11 crore. My submission is if the grant is bail, the trial court also continue, and if any clearance given by the court, I am submitted the whole amount.
I did not follow you. You want to deposit further amount?
Yes, 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 yes. This is the question. If I am wrong, both parties, both company are agreed.
No, out of 14 crores, you say some amount of.
Yes, 283 crore already deposited.
So around 11 crores,
49 lakhs.
11 crores, 49 lakhs is.
Yes.
You want to make some deposit?
Yes, 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 sir.
No, how much will you deposit? The entire amount?
Just give the some time, sir. I'll be arrange the money.
All right. All right. It is submitted, sir. Your good name, sir?
Yeah, Advocate Narendra Bahadur Tiwari, Supreme Court of India.
Okay. Sri Narendra Bahadur Tiwari, learned counsel appearing for the petitioner, submits that out of the alleged misappropriated amount of rupees 143335,923, a sum of rupees 2 point kete? How much is that?
2.8391501.
2 point out into
2.83
91
91 2 कोटी 83,91,000 sorry
283.
We will make it like that. 2 crores. 2 कोटी लगा 2 3 2 3 पूरा फिगर टा
2 crore 83 lakh.
Sir, just
2 कोटी 83 लाख
2 crore 83 lakhs
Already deposited.
91,000 has already been deposited by the petitioner. Stop. As such, the further he is if given granted some time, he would deposit the balance amount of 11 crores and odd. It minus kuri rakhi kete achi hala
11 कोटी 39 लाख 34,922.
So, how much time do you require?
Sir, just
it will always be, sir, I will not grant you bail like that. It has to be always subject to deposit. So, on deposit being made, you will be released on bail.
No, you just give me, you just 2 lakh, 3 lakh. At present, I am given the penalty. After that, you just give 10 to 30 days. The minimum arrangement period. How to, it's not simply 1 lakh, 2 lakh.
No, sir. Sir, maybe you are not aware, but in my court, I always pass order subject to. For you,
no, sir.
Deviation.
Please consider my submission. I am ready to pay. I am ready to pay.
The outsider also, man of Bihar.
Yes.
No, once I grant you even interim bail, what is the guarantee that you will come to the court in Orissa?
No.
We will be left high and dry and we will be searching for you in whatever state you move over. So, unless you make some deposit, sir, unless you make some deposit upfront to show your bonds.
So you just give the figure how much I can deposit.
No, I'm not saying that you must deposit some of the 11 crores.
Minimum 5 lakh at present for the grant of the bail.
No, sir, 11 crores. Sir, you take instructions again. Mr. Tiwari, please take instructions. I'm going to adjourn this matter to 2 weeks further so that you can take further instructions. I'll also ask the State Council. Find out what is the financial involvement of this petitioner. whether he is liable to pay the entire 11 crores or not.
No.
Okay. And since he is also an outsider, there's an added risk of fleeing from justice. That could be also that the court has to see. And you know the Supreme Court decisions where economic offences are to be viewed very seriously. And this is a huge amount. 14 crores, out of which, of course, you have paid 2.83 crores. So come up with some further amount, we can consider. All right. List this matter. The London State Council also would like to take some instructions in this matter. List this matter in the week commencing 22nd April. Yes.
22nd April. Thank you. Highly noted.
Yes.
Okay.
Chala.
22nd. Highly noted.